So here's the process that is typically followed when there's a contested estate. The person who's complaining about the estate and how it's being administered is usually going to complain to the family member and try to get some resolution within the family. And they're going to get the cold shoulder. They're not going to get the information that they want. They're going to feel stymied in some way. And so they're going to go talk with an attorney to see if they can break the logjam. And the attorney is going to help them put together a formal demand for information and also, start talking to friends and family or deceased members of the estate to see if they can build a case. And then they will file a petition in court to have the trust set aside or to compel an accounting, which is fancy words for, compel the trustee to give information about what's happening with the estate, what's in the estate. And they may challenge how the trustee is going about their work or the executor is going about their work. They may challenge whether the whole trust or the will should be blown up. And at that point, the trustee or executor is going to have to talk to their attorney and say how, this is what I needed to do to defend myself. And that attorney is going to do the same kind of investigation. They're going to talk to the family members, the friends. They're going to review the bank statements, the actions of the trustee, and help them to formally defend themselves. And if the trustee is not following all the requirements, then at that point, the attorney can step in and say, this is what you got to do to protect yourself and do this right. And at that point, get them back on the straight and narrow. If the trust itself is being challenged, then there will be some investigation into, the state of mind of the loved one who passed away. What were they doing? Where were they? Were they competent enough? Were they aware of their assets and aware of who their heirs were? Were they competent enough to be able to, write down their will or trust and have their wishes be respected in court? Contested estate litigation can take anywhere from 90 to 120 days at the earliest, or it can take 1.5 years to 2 if it drags out. One of the big factors affecting the timeline of resolving a contested estate is how quickly you can get it in a posture to where it can go to a mediation or a structured settlement conference. Usually that's a good spot at which to resolve it. And then it's just a matter of getting ready for that and talking to the neighbors and getting the financial and medical information you need to be able to have an intelligent conversation there. So the main evidence that you consider in a contested estate litigation is, first of all, the estate planning work that was done. There may have been an attorney involved in drawing up a will or a trust, and so you'll need to consider that attorney's files and the conversations that they had. And someone's going to talk to that attorney. Also, medical records, particularly medical records related to the intellectual capacity and the cognitive capacity of the deceased, as well as medications and the effect that they may have had on cognitive capacity. Other evidence is observations of friends and neighbors and family members who were close to the deceased in terms of evaluating their state of mind. So there are a lot of different possible outcomes in contested estate litigation. If the issue is whether the trustee or executor is doing their job, then usually that trustee or executor can get a legal counsel who will help them to fulfill their duties. And they can, if they're not already on the straight and narrow, they can get on the straight and narrow, and the whole world's going to see that they're doing their job, and the dispute will just go away while they complete the process of administering the estate. If the dispute is whether the trust or the will should be blown up because it was procured by manipulation or fraud or some kind of undue influence, then there's going to be a resolution of that challenge. Either the court's going to make a preliminary determination and say, you just don't have enough evidence and I'm not going to consider it. Unlikely. or it's going to go to a structured settlement process, such as a settlement conference or mediation, and get negotiated, which has benefits, or it's going to go to an evidentiary hearing, and the judge will most likely have, seat a jury to hear the facts and the evidence, and the jury will decide whether in that situation the will or the trust should be blown up. Typically, it's option number 3. It's going to go to a settlement conference or a mediation, and at least the parties then control their fate. They have the ability to shape an outcome that, if not mutually agreeable, at least they can all live with. At the Sierra Crest Business Law Group, we understand how much you want there to be peace and certainty in the family following the death of your loved one. And if you have any questions about how to get to that peace and clarity and certainty in administering the estate of your loved one and resolve the family disputes, give us a call.